Go ahead. Okay, thanks. I did see this. It was on the calendar. I just didn't notice it. All right, good morning, everyone. I'll call the matter of Ramirez versus Murphy.
Good morning, Elder Robert Carroll on behalf of Ms. Ramirez.
Morning.
Apologize for my tardiness. It was beyond my control.
Understood.
Good morning, Your Honor. It's Mr. Murphy.
Mr. Murphy, can you turn your camera on, please? That's the requirement for appearing by Zoom.
Okay, I'm going to try to here. This is the first time I've ever been on this stuff, so.
I'm going to send you a link and you can click on that. So stand by just a second. You should see a little box. You should see a little box that tells you to click on it.
Okay, hold on 1 minute, ma'am. No, I don't see a little box.
Try to find the place that tells you to turn on your video, Mr. Murphy.
At the bottom of your screen to the left, there is a stop video and start video. It's a little camera. If you click on that,
the person speaking now is Jay Shore. He is, according to his screen, a certified ADA advocate.
I hope I don't lose you. I don't see no little camera. All I see is a box and a circle and a diagonal here.
Are you on a phone? Are you on a phone or a computer?
We're going to proceed. Nonetheless, please stop talking, Mr. Shore. We have Ms. Ramirez.
You don't want me to assist him with ADA access?
Mr. Shore, can you please stop talking while I announce the case? We have Ms. Ramirez here in the courtroom. We have Mr. Carroll, her attorney, on the screen. We have Mr. Murphy appearing by audio, and we have Jay Shore here as well. And he has identified himself in a letter as Mr. Murphy's ADA advocate. I continued the hearing from last week. This is Mr. Murphy's hearing on, this is Mr. Murphy's motion to vacate all prior orders issued in the case. As you will all recall, I issued a detailed tentative ruling outlining the entire history of the case, the number of times the case has been on calendar, the appearances made by the parties and their respective attorneys. And I continued the hearing because, basically because of Mr. Shore's comments.
And once again, I want to finish up that I have not been, do not access to this court. My ADA advocate has requested. My accommodations have not been met.
Anything else, Mr. Murphy?
No, Your Honor. Thank you.
All right. Here's what we're going to do, folks. I'm going to continue this hearing for maybe a week. I've already issued a tentative ruling, and of course I will listen to any oral argument Mr. Murphy may have. I don't know why he's not making it today because his ADA advocate is present on Zoom, but I will continue the hearing for 1 week. Let's see what we have available that works for everyone. I have already made some rulings about ADA issues. And I will note for the record that Mr. Shore has submitted a litany of demands for accommodation on behalf of Mr. Murphy. As I pointed out in my, again, very detailed tentative ruling, Mr. Murphy has been represented by counsel throughout the pendency of this action. And although he is not represented today, he has been represented by numerous attorneys in the past. If explanations of court processes were necessary throughout the pendency of the action, which dates back to 2010, as you will all recall, it was Mr. Murphy's attorney's obligation to do that. Mr. Shore's requests and complaints verge on the unlawful practice of law by a non-attorney, or at least someone who is not licensed in the court of the state of California. I did not give prior permission for Mr. Shore to record this proceeding, nor do I give such permission today. Mr. Shore, you will please turn off the recording immediately. No recording is permitted. We have a court reporter in the courtroom, and that is the official and only record. The court finds good cause to deny many of the demands, including the recording by Mr. Murphy, or his companion, by any of the proceedings. The court also denies the demand for a part reporter. Mr. Murphy has already been offered the same courtesies offered to all litigants or lawyers, and that is the right to appear by Zoom unless specifically requested to be present by the court, which I did one previous time in this case, and that was because Ms. Ramirez's attorney had trouble logging in, or some kind of technical trouble. I don't remember what it was. And I did require that all parties appear in court in person, sorry. I always offer frequent breaks to all parties. I always offer the use of a hearing device, which is readily available here in the courtroom if necessary. And I've previously offered Mr. Murphy the ability to have someone present in the courtroom to take notes. Last week when we were here, I offered Mr. Murphy and his so-called ADA advocate the opportunity to take recesses if necessary, but again, this court already provides for many recesses, and therefore, this court has made the accommodations requested that did not alter the nature of the proceedings in court, which is the requirement. Therefore, we are going to proceed with the argument on Mr. Murphy's motion, which I denied for numerous reasons, all specified in the tentative ruling. But most importantly, I should say, I denied it because Mr. Murphy offered no authority to go back in time and deny or vacate all of the orders that this court or previous judges in this court have made, and the time for setting aside a judgment, which was signed back in 2017, has long since passed. Mr. Murphy, if you would like to make your argument, you may do so now. I ask that you speak slowly and clearly so that our court reporter can hear you, since she can't see you for whatever issues you are having with your computer.
Thank you, Your Honor. I do not have ADA access to this court. My ADA advocate has requested accommodations, and those accommodations have not been addressed.
I just addressed them, Mr. Murphy. Would you like to speak to that?
Once again, Your Honor, I do not have ADA access to this court. My ADA advocate has requested accommodations, and the accommodations have not been addressed.
Okay. Well, I will note for the record that your ADA advocate, who apparently lives in Texas, is present. The accommodation that I offered, first of all, he asked to be present by Zoom, and that has been allowed. You asked to be present by Zoom, and that has been allowed, except that you didn't turn on your camera. And I've also offered the opportunity to take recesses if your ADA advocate or you believe that you need that. Any further accommodations have already been addressed. And is there anything that you would like to say with respect to your motion, Mr. Murphy?
Let's take a
Yes, Your Honor.
recess. Let's take a recess.
Are you asking the court to allow a recess, Mr. Shore? Are you asking the court to allow a recess, Mr. Shore?
You said that if we found it necessary,
Mr. Shore,
we
if
could...
you want a recess, you may ask for a recess. You don't get to say, let's take a recess. That is my job.
I've indicated that we need a recess.
We will take a 5-minute recess. Please mute. We'll start back up at I'm sorry? Oh, yeah, if you will. All right, I'll recall the matter of Ramirez versus Murphy. Again, Mr. Shore, your screen says that you are recording this proceeding. I have expressly denied permission to record the proceeding.
Number one, I don't care. Number two, I've given conspicuous notice. Number three, she has not inquired as to whether I am recording. Number four, her continued participation after having conspicuous notice yields mutual consent. Number five, no one else has objected or left. Number six, she has the ability to kick me out if she feels I'm breaking some rule.
All right, Mr. Murphy, are you there?
Yes, I am, Your Honor.
Okay, are you prepared to argue against the tentative ruling?
Yes, I got one other thing. I got per chapter 28, 35.160 B2. You must give me privacy.
You'll have to read that
concerning
again. Mr. Murphy, our court reporter didn't hear that, so please read it slowly.
Per 28, chapter 35.160 B2. You must give me privacy concerning this. So do not ask me again in open court of what your accommodations are. Thank you.
I'm sorry, I don't understand your directive to the court. Do not ask, I shouldn't ask you what your accommodations are?
You shouldn't
because-
discuss his
accommodations
ADA
you gave me.
accommodations.
All
My
right.
ADA accommodations, you have an open court. That's against the rule here, okay? So
Okay, well,
please don't
just for
ask.
the record, if you were here, you would know that there is no one else in court except Ms. Ramirez.
I
But
would have been there, Your Honor.
Mr. Murphy, please stop interrupting me. The court reporter cannot listen to two people at the same time, and you're the one who requested a court reporter, so.
This is what people with disabilities face on a regular basis. They go into a court, there's somebody up in front that's supposed to be professional and courteous, and just saying the wrong thing can send them into a spiral of rage and haughtiness and feigned humility when she put her hand up to her chest and said, "Are you asking the court for a break?" And that was just a setup, and as I showed. And the thing is, this judge, Christine Carringer, she's a real piece of work, but I'm not the only person that has complaints about her. She seems to be a real problem for the Solano County Courthouse. For litigants who go in and try to get justice. There is no justice in this court. So, you know, I'm telling you this as a layperson, an ADA advocate, and just putting this out there. This is how my life goes. If you're going into court by yourself against this kind of tyranny, you can expect to be hammered even harder.